You know that notebook you kept of every conversation you had with the treating doctor? Of every single nurse that came in? About every single thing that was done? Did you know when you bring a lawsuit seeking compensation for all the harms and losses and damages that you incurred, one question you will be asked during the course of your lawsuit by the attorney who represents the doctor or the hospital will be, "Hey, Mrs. Jones, do you have any writings, any calendars, diaries, notes that you made at the time that these conversations and these events were happening?" Do you know that you will be asked that question? And the answer to that question may cause you lots of grief. You want to know why? Come join me on this walk through the neighborhood as I tell you exactly why. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, so here's the scenario. You were in the hospital and now you feel that you wanted to record everything that was going on because your memory is not so great. So you sit there with a pen and paper every time a doctor comes in and you take detailed notes. Every time a nurse comes in, you want to know what's happening. And you have that right. You have that right to record so that you have an understanding of exactly what went on. So now multiple doctors come in over the course of days and weeks, and you're recording notes and you're writing up and you're typing stuff and you're even taking pictures and videos of what's going on. And you know what? That's great. This way you know that you have a detailed record of everything that went on. You're not going to rely solely on what went on in that medical record that the doctors and nurses are keeping. Instead, you're relying on your own notes about the events that occurred. Now, as you're receiving treatment in the hospital, you're not thinking about something that was done wrong. You're just trying to get better. But still, you want to record this information for posterity because you want to be able to go back and look if, God forbid, you ever need it and say, oh yes, here at this date, at this time, this is what happened. This is what the doctor said to me at that point. So guess what happens? You believe during the course of your hospital stay, a doctor was careless and caused you significant harm and injury. And now it is your intention to bring a lawsuit against the careless doctor who treated you at the hospital. All right, you have that right, provided that a medical expert confirms that you have a valid basis for a case, that there was wrongdoing, that the wrongdoing was a cause of your injury, and that your injuries are significant or permanent. All right, so let's say that a medical expert has in fact confirmed that you have a valid basis for a case. During the course of your lawsuit, we have to turn over copies of your medical records. We have to turn over any statements we obtained from various witnesses. We have to turn over any photographs or videos that we intend on using to prove and to show that the defense was careless and violated the basic standards of medical care. They're required to get that information. And if we do not disclose that information and try and use it to ambush the defense at the time of trial, you know what's going to happen? The judge will not allow us to do that. And the judge will yell at us for not disclosing that information. So it is our obligation to go ahead and turn that material over. Now, the moment we say that you have detailed notes about the events that transpired, you know what's going to happen? We are technically obligated to make copies of those, to disclose them to the defense, and to provide them with copies of all of that information. And as a result of that, the defense will spend days scouring through every single page of every single note that you made while in the hospital. The defense will scour every single word to see what it was you claim was done at the time you're making these notes. And that's not all. What else will happen? During the course of your lawsuit, you have to appear in our office for a question and answer session. We call it a deposition. Lawyers also call it an examination before trial. Now, that's nothing more than being asked questions by the defense attorneys. In that instance, you will be in our office. There's no judge present, there's no jury present, but there is a court stenographer there to record all of the questions you are asked and all of the answers that you give. And that is sworn testimony, and it carries the same exact weight as if you are testifying at the time of trial. So now, what's the big deal? The big deal is that now, in addition to asking you questions about everything that happened, the defense will want to go ahead and turn around and ask you hundreds, if not thousands of questions about every single note and every single entry that you made in your notes. They will want to know everything about it. When did you write this? Why did you write this? Why did you write certain information and not others? Tell me about the conversation that you had with the doctor that's reflected about this note. Explain that to me. And now they will go through each and every entry. Why? Because they're entitled to learn what you know. They're entitled to learn what happened. Remember, these attorneys were not there. They only have the medical records to rely on, and they have the memories of the doctors that they represent, as well as your memory to determine what actually occurred. Now, in some instances, having these writings may in fact help dramatically. Why? Because you've got some doctor who now 3-4 years down the road is being asked questions about the events that occurred. In all likelihood, he's not going to remember the specific details of the conversation that you had with him. However, you now present these writings where you clearly indicate the exact details of what occurred. And many times you will use this to refresh your memory, to help you remember exactly what the conversation entailed. So when you are first evaluating whether or not you even have a valid basis for a case, one of the first questions I will ask is whether you have any notes, any diaries, calendars, anything to reflect conversations that you had with any of your treating doctors or nurses, because that's critically important to understand whether there's information in there that's going to help us later on down the road. Do we have to disclose that information? Absolutely. If we intend on using that information, either refresh your memory or to use it to show that certain conversations took place, it will be extremely helpful, and then we do have to disclose that information. If we do not disclose it, you won't be able to turn around and say, oh yeah, I reviewed my notes prior to coming here, and my notes say the doctor said A, B, and C. Well, in that instance, if we don't have that information, how does the defense attorney know that what you are claiming is true? If, on the other hand, you go ahead and present those notes, and now we show them that these are the notes that you made at the time that these events are occurring, well then guess what? Now it lends more credibility to exactly what you're talking about. So why do I share this great information with you? I share it with you just to give you a real insight into what goes on in these medical malpractice cases. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York, but you have not yet started a lawsuit, but are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.